5 seconds to go. Start. The petitioner has not paid the security deposit, but however obtained a direction from this honorable court to accept the bank guarantee towards the security deposit and furnish the same to the second respondent along with his consent letter dated 28th February 1995, accepting the conditions stipulated in letter number 82 dated 13th September 1994. In the said letter dated 13th September 1994 of the second respondent, one of the condition is that the petitioner should hand over the 10% open space reservation area to the Commissioner Corporation of Madras free of cost through a registered gift deed, which is a lawful condition under Development Control Rule 19B second. It is respectfully denied that the petitioner has not made any representation to relax the condition of gifting of the open space reservation area, and the same was never under the consideration of the second respondent. It is submitted that the second respondent has requested the petitioner to transfer the 10% open space reservation area free of cost through a registered gift deed in favor of the third respondent as per the provisions of Development Control Rules 19B second under Group Development Regulations and not as contended by the petitioner. The requirement to maintain the OSR area in the absence of the demand for a gift, it could be said that the sole project of proponent could have the right to remain in possession. Another dimension may be noticed. What would happen if the OSR area is acquired in the exercise of the power of eminent domain for the public purpose? Who would be entitled to the compensation if a gift is made in terms of the impugned rule regulation? We would think that since the interpretation we are placing is that the gift under the rule regulation is intended only to ensure due compliance with the requirement of the OSR area being effected and to prevent misuse by the owner, as between the original owner and the local authority, it would be the original owner who may be entitled to the compensation. The time, therefore, is ripe to deal with the meaning of the words open space reservation of land for communal and recreational purposes. Group development falls under Rule 19B second of the DCR. Group development is defined as accommodation for residential or commercial or combination of such activities housed in two or more blocks of buildings in a particular site, irrespective of whether these structures are interconnected or not. Rule 19B second proceeded to provide for the minimum width of the public road on which the site abuts. The vehicular access way, including passage, if any, within the site was to have a minimum width. It also referred to setback requirements. Parking standards were prescribed. It is thereafter that the open space requirement was provided by declaring that reservation of land for communal and recreational purposes shall be as follows, and it must at this juncture be noticed that there is an explanation which reads as follows. For the purposes of these rules, existing development defined as 1 where the extent of ground area covered by structures already existing prior to application in 25% and above of the total site area. In case of existing development where it is difficult to leave the 10% area as open space for communal recreational purposes, the authority reserves the right to collect the market value of equivalent land in lieu of the land to be reserved. However, if on a future date the developer wants to demolish the existing structures and raise new structures, stop.